Relief from tax burden in sight for Nigerians as Tax Reforms Committee submit its quick wins report.
Senate to investigate trillions of naira spent on turnaround maintenance of refineries since 2010.
As Minister of Defense meets service chiefs, reiterates plans to combat all threats undermining national peace and unity.
And on Good Morning Nigeria today, we discuss matters arising from the P&ID judgment.
Five long years of legal battles between the federal government of Nigeria and Process and Industrial Development P&ID Limited have ended in favor of Nigeria. The judgment delivered in a London court on Monday quashed an $11 billion arbitration award in favor of Nigeria.
Now, the decision delivered by email upheld Nigeria's prayer on the ground that the ill-fated gas processing contract was obtained through fraudulent processes. Now, the court dismissed the $6.6 billion arbitration judgment earlier against Nigeria, of which interest had increased to $11.5 billion.
The ruling also indicated that what had transpired in the case was contrary to public policy. The entire saga began after P&ID had in 2010 agreed to build a gas processing plant in Calabar, Cross River State.
When advised by the Ministry of Petroleum Resources along with other bid winners for Nigerian gas flare commercialization program to hasten site development, P&ID claimed that the contract had failed because the Nigerian government did not fulfill its end of the bargain.
P&ID alleged that this violation frustrated the construction of the gas project agreed to during the government of former President Umaru Musa Yar'Adua and deprived it of the potential benefits expected from 20 years worth of gas supplies with anticipated profits of $5 to $6 billion.
P&ID then took a legal recourse, securing an arbitral award against Nigeria. Now, a tribunal later ruled in January 2017 that Nigeria should pay P&ID $6.6 billion as damages, as well as pre- and post-judgment interest at 7%.
After this judgment, Nigeria applied for an extension of time and relief from sanctions. The country's application was granted by a judge of the Business and Property Court of England and Wales in September 2020, returning the case to arbitration.
Nigeria's ground was that the gas deal was a scam conceived to defraud the country and that P&ID officials paid bribes to secure the contract. These were allegations that P&ID itself denied, accusing the Nigerian government of what it called false allegations and white conspiracy theories. Now, matters arising from the P&ID judgment, of course, will be our focus today, because we also need to remember that P&ID was said to have no capacity whatsoever in executing that contract. We shall be looking at the various ramifications of the decision and what next will follow. We are live on the network service of the Nigerian Television Authority, and it's Good Morning Nigeria. I'm Kingsley Osadolo.
And I am Ademola Adeoye. We are reaching you from Nigeria's capital city, Abuja. Welcome to the program. In the course of the program, we will bring you some business news, and much later we'll review the newspapers. Olajide Bello will give us highlights of the morning news. Hello, Olajide. Good morning to you.
Good morning, Demola and Kingsley. Good morning, Nigeria. And here is the news. The Presidential Fiscal Policy and Tax Reforms Committee is set for another phase of its task to reduce tax burden on Nigerians. This follows submission of its quick wins report to President Bola Tinubu at the State House.
The most sustainable way for any country to generate revenue is to grow the economy. When businesses succeed, when individuals prosper, they pay taxes. For us, that's the most fundamental. So we're looking at how can we remove the impediments to businesses, to trade.
Senate has resolved to investigate the more than 11 trillion naira allegedly spent on turnaround maintenance contract of the 3 refineries in Nigeria from 2010 to date.
And how do we explain to the whole world that we have expended this so much on renovation of our refineries and not for one day as the refinery function?
This matter is something that touches on our country, the economic well-being of our country. It's eating deep into our finances.
The House of Representatives has resolved to invite the Governor of the Central Bank of Nigeria to appear before its committees on banking regulations, finance and customs to explain the rationale behind the policy of lifting forex restrictions on 43 commodities. The House expressed concern that the policy could be inimical to local production and economic growth.
Cement and palm oil, among others. Those in support of this motion should say aye. Aye. Those against should say nay. Nay. The nays have it.
The Chief of Defense Staff, General Christopher Musa, says the armed forces remain dedicated to ensuring democracy thrives and prepared to combat threats undermining peace and unity. The CDS stressed this while receiving the Minister of Defense, Muhammad Badaru Abubakar, and Minister of State for Defense, Bello Muhammad Matawali, on a working visit to the Armed Forces Complex, Abuja. It's just 2 weeks to the Bayelsa, Imo and Kogi governorship elections, and INEC Chairman Professor Mahmoud Yakubu is concerned over the increasing spate of court judgments that may affect preparations. The chairman expressed this in a meeting with political party chairmen in Abuja.
The Commission has already published the final list of candidates for the 3 states. 4 recent court orders have compelled us to review the list. These changes have been reflected in the updated list of parties and candidates.
A vaccine to roll back the prevalence of human papillomavirus, one of the major causes of cervical cancer among women, has been launched in Nigeria. Nigeria's First Lady, Oluremi Tinubu, performed the flag-off ceremony in Abuja.
The initiatives does not end with the introduction of the vaccine into our routine immunization schedule, but we must encourage regular screening, improve access to health care, behavioral interventions, and early detection.
The Lagos State Sexual Offences and Domestic Violence Court, sitting in Ikeja, has convicted and sentenced a 57-year-old medical doctor, Olufemi Olaleye, to life imprisonment for defiling his wife's niece. The presiding judge, Justice Ramon Oshodi, gave the other in criminal allegation which the Lagos State government preferred against the convict. Justice Oshodi jailed Olaleye, the founder of Optical Cancer Care Foundation, to life after holding that the prosecution has proven the allegation of sexual assault against him. The state had arraigned the convict before the court over allegations of having unlawful sexual intercourse and sexual assaulting the 15-year-old minor by penetrating her mouth using his organ. The convict allegedly committed the offences between February 2020 and November 2021 on Lai Ogunbambi Close, Maryland, Lagos. The alleged offences contravene sections 137 and 261 of the criminal laws of Lagos State 2015. Justice Ramon Oshodi heard earlier dismissed a no-case submission application by the convict for lacking merit and asked him to enter his defense. The court held that the evidence adduced before the court against the defendant was compelling and proven beyond reasonable doubt. Nigeria will apply the needed political will to unlock its broadcast potential and facilitate the digital switch-over processes. Minister of Information and National Orientation Mohammed Idris at the 2023 Africast in Lagos said the broadcast industry is pivotal in the government diversification drive.
Our goals of creating jobs, tackling poverty, building the skills and capacity of our people, and ensuring that no one is left behind can only be achieved in partnership with.
And that's the news for now. Good morning, Nigeria continues with Kingsley and Ademola after this break.
Reform may be painful, but it is what greatness and the future require. We now carry the cost of reaching a future Nigeria where the abundance and fruit of the nation are fairly shared among all, not hoarded by a select and greedy few. A Nigeria where hunger, poverty, and hardship are pushed into the shadows and ever-fading past.
The office of the First Lady of the Federal Republic of Nigeria, Senator Oluremi Tinubu, CON, is organizing a 3-day protocol and security seminar for female federal legislators, wives of legislators, female members of the Federal Executive Council, wives of governors, female deputy governors, female local government chairmen, wives of traditional rulers, and female top government functionaries. The 3-day seminar holds between Thursday 26th of October to Saturday 28th of October at the Banquet Hall, State House, Abuja at 9 a.m. daily. Facilitators are drawn from the Ministry of Foreign Affairs, the National Intelligence Agency, Office of the National Security Advisor, the Nigerian Police Force, Nigerian Immigration Service, and the Nigerian Customs Service. This seminar is strictly by invitation. Announcer Busola Kukoyi, SSA Media, to the First Lady of the Federal Republic of Nigeria.
Buy a Risco product.
Good morning.
My life is a whole lot easier now, even when I'm working from home. I still get everything done.
Workout track.
And faster too. Guys, I'll make my decision and get back to you.
You are still on to Good Morning Nigeria, coming to you from the Federal Capital Territory, Abuja. Stakeholders at the just concluded 29th Nigeria Economic Summit say effective coordination is key to realizing economic goals. They also suggest an increase in investment, innovation, employment, and trade competitiveness to further reposition the economy. Alika Okpanachi Arua has more on business news.
Participants at the 2-day economic summit in Abuja says to address Nigerians' foreign exchange earnings and remittances from abroad, there must be an increase in productivity, reduction in inflation figures to attract foreign investors into the country, alongside public-private partnership, policy consistency, as well as transparency.
We've had a lot of industrial plans that outline the areas that we think we should be focusing on, like agriculture processing, battery technologies, gas value chains, textiles. What has been missing, and this is something we can do today, even without a lot of resources, is vision from the top, all the way to the presidency, to drive hope. Because if people are not hopeful about the future, they will not invest in production.
There are success stories which, are very encouraging. The important thing now is on how we get a consistent level of execution and implementation. And it comes from both sides, from government and also from the organized private sector.
They also insist that the current gaps in infrastructure should be addressed to serve as a catalyst for these required developments. Let's take a look at Tuesday tradings on the floor of the exchange. With business news, Alika Okwanachi Arua.
Many thanks, Alika Okwanachi Arua, for the business news package. Coming up next, a review of the front pages we have this morning.
Welcome our newspaper reviewer Chooks to the program this morning. Chooks, how are you doing today?
I feel fine. I feel good, like Papa JB. I don't know what's responsible for it. Maybe I'm going to make some money later in the day. I don't know.
No wonder you're in top spirit.
Thank you so much. It's part of my boyish disposition. Hello, Kingsley. You're joking for UTME. You passed that a long time ago. UTME, that
you were during our time. It wasn't called UTME.
I'm not like to find trouble because I get into trouble myself in the process. How are you doing?
Where you were reminding me of the Godfather of Soul.
Yes,
James Brown.
A pig.
It was a
great man. I was looking at choreography coming from him the other time. How did he manage to move those feet the way he did?
Well, practice. And certainly, and you know that the moves by Michael Jackson,
yes,
were borrowed from
copied.
From James Brown, and well, that's it.
No,
but you remember James Brown? James Brown had a tour of Nigeria after the Civil War ended in 1970. He came around, and one of the places where he performed was at the Ogbe Stadium in Benin. I was too young then to go because my uncle said he wasn't going to take me along with him to go watch JB. When he came, after he left Nigeria, there was the dress, a fashion style that began to reign, the bell bottom, what we call labu. That's street food.
We call it jabba trousers. There goes the library again. You better stop it. I don't know how he warehouses all the things he says.
I don't know. Anyway, let's just take the newspaper headlines for today. And I will start with the Daily Sun. And with the headline, Atiku's bid to expose FBI, CIA's records on Tinubu's fails. U.S. court rejects request to compel security agencies to release documents on Nigeria's president. Nadeko asks FBI to investigate Chicago varsity over certificate. Inflation rate to hit 30% by December. Red summons CBN boss over reversal of ban on rice importation and others. And that story can be gotten on page 25 and 27. Peter Obi taxed judiciary on election petitions, says democracy based on faulty justice opens society to dangers. The story is on page 6. Bandits attack mosque, kill 2. Injure 2 worshippers in Kaduna. That story can be gotten on page 4. Jonathan makes case for inclusive democracy, stronger institutions. The story is on page 26. Nigerian company launches unmanned area vehicles, drones production. The story is on page 29. Kogi, Imo, Bayelsa. INEC frowns at political parties' non-nomination of agents. The story can be read from on page 18. Ground rent debt. Wike issues fresh threat, vows to step on toes. Page 27. Moribund refineries. NNPCL faces 11.35 trillion probe. GMD orders summoned on page 28. Federal government states LGA's shares 903 billion in September. The story is on page 25. Federal government obtains fresh $17 million loan from World Bank. Facility meant to support adolescent education. The story is on page 2. Alleged P&ID scam. EFCC opens case against fleeing Britain. That story, it's also on page 5. And moving on to Daily Trust. Below the nameplate, we have Kogi Bayelsa Imo governorship polls. INEC chair raises alarm over violence. Elder statesman Adamu Fika dies at 90. The story is on page 4. War on Gaza. UN Secretary General accuses Israel of violating international humanitarian law. Says we must oppose anti-Semitism, anti-Muslim bigotry. Israeli ambassador calls for Guterres' resignation. Israeli police shot down al-Mosque. And the story is on page 4. How banditry forced Zamfara residents out of their homes. The story is on page 23. SEDI defends exotic cars for members, says Nigeria roads are bad. The story is on page 6. Bandits raid Kaduna Mosque, gun down imam or worshippers. Page 8. Lagos doctor bags life jail for defiling wife's knees. The story is on page 17.
Okay, we also have the Punch and Leadership newspapers. I just pick out some of the headlines since Demola has read similar headlines from the other two papers. So the Punch, above the nameplate, EFCC chair orders staff to declare assets. That's page 7. Multiple taxation. Tinubu panel asks government to drop 190 taxes. OPS, that's organized private sector, blames states. Panel okays 10 levies, says 200 taxes burdensome, lobbies National Assembly and states. President endorses tax reforms, and panel to address FEC and FIRS pledges implementation. DSS nabs suspected terrorist wife, recovers 150 AK-47 rifles. Slain Nigerian student. Philippines police file murder cases against suspects. From the Leadership, above the nameplate says NNPP tackles Ganduje over Kano foreign scholarships. Tax evasion. Appeal tribunal orders MTN to pay FIRS $72.5 million. And the story is also here. Senate defending the purchase of SUVs, says it's for durability. 18 days to governorship polls. Bayelsa Kogi Imo election materials not ready. INEC blames litigation and intra-party crisis. Restore public trust in the electoral system. That's IPAC. CDS warns stakeholders against violence. And Israel-Hamas war. UN expresses concern as death toll hits 7,200. Flights resume at Kaduna Airport. Chukudi.
Yeah, thank you, Kingsley. Quickly, Senate defense exotic cars for members, says Nigerian roads are bad. The Senate is not disputing the word exotic. So a point of English grammar here. Exotic is not exactly rugged. Rugged and exotic are two different things. So if you're saying it's because Nigerian roads are bad, rugged is the word. Exotic has synonyms in the shape of alluring, fascinating, luxurious, and the rest of it.
Yeah.
So let's not be beguiled in that area. The point is, exotic means not native, foreign. And that begins to make you ask, why are the lawmakers not being part of effort to at least make the assemblage of cars in Nigeria a reality? I'm not even going to go the innocent way so that we don't begin to impute certain things into it. But remember, Kingsley, the other time I said at Banya, state of Banya, Brazil, Salvador, the Brazilians told me, I saw their cars, and they said, Jeeps are rare here. We prefer to drive cars we make ourselves. The parading of opulence. Imagine what the chairman of the Senate Committee on Senate Services, Sunday Karimi, is saying here. He says the criticism is uncalled for. After all, ministers have even more cars. He goes on to say a minister has more than 3 Land Cruisers, Prado, and other vehicles, and you're not asking them questions. Is it a competition over being flamboyant? We have to be careful about these things. Our lawmakers should not parade poverty, for crying out loud. They deserve good things, because they will be messengers of, you know, whatever noun you want to put in there. But there are certain things to do within the polity that do not quite reflect the mood of the nation. That's the point people are making.
Especially now that the president is calling for all to cut costs. You understand? The last time he appealed to the ministers, government officials, to find a way to reduce the cost of governance.
Exactly.
You know, in the light and the mood of the nation. So I don't understand.
But must it be 2023 sports utility vehicles anyway? 2023.
No, I think what they should get Rolls Royce. They should get, if they can't find our Cadillacs. I mean,
it just spoiled the whole thing. It made it worse.
Sometimes I begin to think that we have inferiority complex.
Seriously.
I'm sorry, but I do think that from time to time.
Get them Caddies.
Caddies, okay?
Caddies.
Yeah.
Rolls.
The big.
Or Bentley.
And they can compete with James Bond.
Absolutely.
Because it drives the Bentley.
Let it go.
Anyhow, please, gentlemen, quickly, Tinubu panel asks government to drop 190 taxes. Organized private sector blames states. They say that the states are usually the ones who are guilty of multiple taxation. And they are saying that multiple taxation leads to rising production costs, which in itself leads to reduced profit margins, supply chain disruptions, and reduction in customer spending. My problem here is that the organized private sector is talking about themselves. They are not saying that it's a strain on the pocket of the customer himself. But the point being made here is that in the drive for internally generated revenue, sometimes we get ridiculous. And that does not help grow the economy in the long run. You understand? So it matters that the laws you put in place now are ones that are going to encourage productivity. It would seem that with those multiple taxation, you are with those acts of multiple taxation, you are getting more cash, but you're stifling the economy, over time. So it matters that the panel, the presidential panel, is actually talking about this. It was so annoying. Anytime I got to Benin bypass, and somebody was asking me for my radio, TV, my radio license and all that. What actually pained me more than anything else was, should it be the local government asking me for a radio license, like my car? When broadcasters are suffering, are in penury over keeping the signals going to homes, who should actually get that? But that's an aside. The point is, do not stifle the economy in the long run because you want a quick cash. It has economic implications. Okay. That's it there.
There is a story that, of course, we have read from the front pages.
Kingsley, sorry, let's not fail to say adieu, Adamu Fika. Only a few Nigerians are still statesmen. You understand?
That's right. Adamu, he was a great Nigerian. But I just want to return to this story, and it's about the medical director who's been sentenced to double life
imprisonment, yeah,
for defiling the niece of his wife. Now, the medical doctor is 57 years old, it's said. He committed the offenses in between February 2020 and November 2021, somewhere in Maryland and Lagos. The niece, who was defiled, 15 years old. He was arraigned last year in court, that's in November. So within a year, the case has been tried and it's been convicted and sentenced. It's a great tragedy for one, the medical profession, two, for the family, and three, for persons who care about the decency of having medical personnel in whom you could place your trust. Now, he is a medical director in charge of optical cancer care. We have very few cancer specialists.
Oh, that's great.
In this country.
Yes.
In this country. When Dr. Bello, one of the cancer specialists who always on Good Morning Nigeria, when he's discussing the death of cancer specialists in the country, it's one of the reasons why fatalities from cancer are pretty high. What it takes to train an oncologist.
Yes.
It's a why. And now this medical doctor, on account of his extreme indiscretion, which is condemnable, has given himself the opportunity of earning 2 life sentences. That's probably with no opportunity of parole.
And he's denying us his services, which are rare.
That's the greater tragedy. Because you keep him away because of his behavior.
Yeah.
You keep him away because, of course, he's a threat and a nuisance to society. And then he's especially somebody who's been trained to prove. And his skills are right. So how do you, I'm not asking for balance. I'm not saying balance this, but just to appreciate the enormity of the double tragedy that has happened. Society would not get the quality of his services, but his behavior makes him a nuisance to society. So keep him in the can for the rest of his life. 57 years old.
And he's still very young.
It's unfortunate.
It's really, really
we're not going to, it might sound laughable, you know, we're not going to let him go. We're going to set up a theater for him in prison so that he must give us those services. Because jokes aside, well, that's a joke. The truth is that the real tragedy is that we're losing those expert services.
The tragedy is that we are losing the experts.
That's
Thank
the
you
point.
so much, Chooks, for the newspaper review this morning. Thanks for your contribution.
Thank you so much.
We'll now take a break. Good Morning Nigeria continues after this break. Stay with us.
Nigeria means a lot to me.
And Nigeria means peaceful cohesion. My country.
Well, we continue to pray, and then hopefully we will come to understand that unity of purpose, unity of living together.
Our ethnic beliefs and background and culture is our strength.
Ever since the amalgamation period of 1914 to date, about 109 years ago, the people of Nigeria live very peacefully with one another.
I think diversity helps a lot to enhance robust development in Nigeria.
All over the country, you know, you have so many ethnic groups, over 250. That is enough to tell you that this is a blessed country, and you know that God has kept, you know, together as one indivisible entity.
Something new is about to hit your imagination of TV. A brand new sundial with StarTime's inbuilt technology. New TV innovation with an inbuilt decoder that connects you to both StarTime's antenna and satellite signal. StarTime Sundial TV, you can enjoy over 300 local and international channels, 1 month StarTime's highest bouquet for free, automatic system update. More benefits, more affordable. StarTimes Sundial TV is available in all StarTimes branches and dealers countrywide. StarTimes Inside, entertainment inbuilt.
Those who desire to upskill their skills and remain relevant in their organization can fulfill their desire through the following training programs specially packaged by NTA Television College, Jos. Audio Engineering, Operation and Maintenance, date 3rd October to 13th October 2023, 2 weeks. Photojournalism and Photography, date 16th October to 3rd November 2023, 3 weeks. Advanced Broadcast Accounting and Auditing, date 6th November to 17th November 2023, 2 weeks. Television Graphics Design and Presentation, date 6th November to 24th November 2023, 3 weeks. Managing the Boss, date 27th November to 1st December 2023, 1 week. Advanced Protocol, Event Management and Public Relations, date 27th November to 8th December 2023, 2 weeks. Parliamentary Reporting and Management, date 27th November to 8th December 2023, 2 weeks. The course fee for the 3-week course is 150,000 naira per participant. The fee for the 2-week course is 120,000 naira, while the course fee for the 1-week course is 100,000 naira only, accommodation inclusive. The venue for all courses is the serene and secure environment of NTA Television College near Old Government House, Rayfield, Jos. For more inquiries, please call 0803 079 5335 or 0806 980 9807. NTA Television College, Jos, training you to be the best you want to be.
Making the economy more robust by lowering transport costs shall be key. In this regard, we have opened a new chapter in public transportation through the development of cheaper, safer, compressed natural gas, the CNG, buses across the nation. These buses will operate.
Welcome back to Good Morning Nigeria, coming to you from the FCT, Abuja. As a prompt for our conversation on matters arising from the P&ID judgment, let's take this background by Abdusalam Jubril.
On Monday, 23rd October 2023, was a day of celebration for Nigeria after it was reported that the country won her bid in a UK court to overturn an $11 billion damages bill filed by UK firm Process and Industrial Development's P&ID over a failed gas processing plant contract. The Business and Property Court in London upheld Nigeria's prayer on the ground that the ill-fated gas processing contract was obtained by fraud. Recall that the P&ID controversy dates back to January 2010 when the company signed a gas supply and processing agreement with the Ministry of Petroleum Resources on behalf of the Nigerian government. Under the fine print of the agreement, P&ID was to build and operate an accelerated gas development project to be located in Cross River State, while the Nigerian government was to source natural gas from oil mining leases 123 and 67 operated by Adax Petroleum and supplied to P&ID to refine into fuel suitable for power generation in the country. However, P&ID alleged that after signing the agreement, the Nigerian government defaulted on its obligation. The company subsequently took a legal recourse and secured an arbitral award against Nigeria. In 2017, a tribunal ruled that Nigeria should pay P&ID $6.6 billion as damages, as well as pre- and post-judgment interest at 7%. Following the judgment, Nigeria applied for an extension of time and relief from sanctions. In 2020, the case was returned to arbitration after the application was granted by the courts. In March this year, Nigeria alleged that the contract was secured through dishonest means that included bribery and perjury, and that the arbitration award, which has now risen to $11 billion because of interest, should be quashed. With the judgment handed down physically in open court and electronically by email to the parties on Monday, Nigeria has succeeded in putting a stop to the enforcement of the award, which was initially in favor of P&ID. What does this judgment mean for Nigeria? Will those involved in a controversial contract be persecuted? Are mechanisms in place to forestall such occurrence and ensure transparency? These and more will form the crux of discussions as guests speak to the $11 billion P&ID controversy shortly.
Thank you very much, Abdul Salam Jibril, for that background. With us here in the studios, we have two regular guests on Good Morning Nigeria. First, let's welcome distinguished Senator Ita Enang, a legal practitioner and former presidential aide. Dr. Enang, we're glad to have you on the program this morning.
Thank you very much, and good morning, Nigerians.
Also here with us is Odion Omofoma. Odion Omofoma is an energy expert and managing director, New Hampshire Capital Limited. Odion, morning, I'm glad to have you.
Thank you very much. Good morning, Nigeria.
Also joining us via Zoom from Coventry, UK is Lateef Yusuf, legal practitioner in the United Kingdom, ADR enthusiast, civil litigation expert and consultant on international arbitration. You're welcome, Lateef, to Good Morning Nigeria.
Good morning. Am I audible?
Yeah.
Yes, yes, we can hear you.
Thank you very much. Good morning. I'm happy to be here.
Okay. Let me start from you, Lateef. Let me ask you, can you give us an explanation, a background of the P&ID case and how we got to this point? Just give us a background.
Yes, in a nutshell, today's judgment is a long chain of events. And we actually celebrated last year when Nigeria was given permission to challenge or to bring a challenge before the High Court in England on the basis of fraud. So the fact that a permission was given to Nigeria, that Nigeria does have a valid case against P&ID based on fraud. So from last year, we knew it was just a matter of when, not if. So today's judgment is just accumulation of all that we had expected. And I have a small group of about 6 or 7 other lawyers that we've been following this case for the last 10 years and all the intricacies. So the background is quite simple. 2 Irish businessmen with a company registered at the BVI, that's the British Virgin Island, came to Nigeria, and they did a few businesses related to defense, supply, that kind of typical business where a ministry would request that something be supplied and they would give them the contract. So they would then facilitate the supply, both in terms of human personnel and sometimes some military equipment. So that's been what they did. Now, the initial brush with energy came with an alpha project. So the alpha project was the first time P&ID sort of had a direct involvement in the energy industry. So it was for building of some gas projects. It was more like a gas swap because Nigeria didn't really know what to do with gas. We would flare gas, and during the Yaradua era, they created more like an emergency meeting where they said it was time to stop flaring of gas because, of course, it could unlock revenue, and due to the climate change, advocates talking about the fact that climate change is adversely affected when Nigeria continues to flare this gas. So what did Nigeria do? Nigeria sort of tinkered with the idea of creating sort of an arrangement where people in the exploratory industry, in conjunction with the NNPC, would then come together and find reputable companies that can sort of take this wet gas, as it's called, it's like a raw gas, and then process, make it refined and usable. So, but that alpha project failed. Then over time, they sort of used the alpha project model to model what they call the GSPA agreement that was signed with the relevant ministry, and a lot of things went down the line. So what this judgment sort of uncovered, number one, was the fact that the 2 businessmen were heavily involved in unethical practices. So they would sort of influence and basically civil servants to do their bidding. And it's quite instructive to understand that an energy swap agreement, or rather a gas swap agreement of that magnitude that would generate billions of dollars, had an agreement of just 20 pages. Now, even if you want to build a skyscraper in Ikoyi that would maybe house a couple of people, you would have an agreement running into hundreds of pages. There will be things of town planning, a lot of things that will be incorporated into it. But an agreement that would generate billions of dollars, it was just 20 pages. So that was a little bit suspect. And the judge made that very clear in that very well received judgment of 140 pages. So we are here now, and there are a lot of lessons we could learn. And I could go on and on about a few things, but essentially there was an arbitration. So it was a 3-man tribunal chaired by Lord Hoffman. Our own Chief Bayojo was the arbitrator appointed by Nigeria. Thankfully, and this is more like a vindication for Chief Bayojo, Chief Bayojo did not agree with the panel, with the tribunal at the quantum stage. So liability, yes, Nigeria didn't do what they were supposed to do. This contract was frustrated, repudiatory breach, all that. But Chief sort of disagreed with the fact that a rookie company, a company that has never done extensive energy work, is presenting damages into billions without necessarily looking at the very unique nature of running business in Nigeria. So Chief gave a dissenting award. So he did not agree with the other 2 arbitrators, and he awarded less than 10% of the 6 billion. So he awarded less, around, I think, if I could recall correctly, he awarded maybe $500 million. That was what he could award. And yesterday I was telling someone, I said, this is a vindication for Chief Bayojo SAN, who happened to be the former Attorney General of Federation. And there was a portion of that judgment that actually dealt with the fact that the nature of arbitration, even with an experienced tribunal, you could have people sort of use arbitration as a means to sort of rubber stamp fraud, unlike what you would have in an open court system. Arbitration is confidential, it's private. If an arbitral hearing is happening, it happens maybe in a hotel lobby. Nobody knows there's an arbitration except you are into the arbitration community. That's when you know, okay, this arbitration is ongoing. So it's away from the public, and there are so many reasons why companies opt for arbitration. They would opt for arbitration basically because they don't want their business out there. It's supposed to be faster.
Latif, thank you very much. Let's pause you. In the meantime, we have 2 other guests here in the studios so that they can also weigh in on this very significant development. And by the way, the decision was given on Monday. That's 2 days ago, not today, Wednesday. Let's begin with Senator Ita Enang. As it were, Nigeria dodged a bullet. And this was a bullet aimed at our jugular, as it were. But in very suspicious circumstances all along. How do you contextualize this in our public transactions and the role of government officials? Almost some would say, but the lack of diligence.
Thank you very much, and let me congratulate Nigeria being able to successfully come out of this. And let me also congratulate the former President Buhari, who took it very seriously, the former Vice President, Professor Simbanjo, and the learned Attorney General Malami, and of course the Minister of Information, who led a team who were involved in the cause of trying to let government pursue the defense and how to get out of it. Let me congratulate them, and again congratulate His Excellency the President Bola Tinubu, because it is in his era that this continued and we have this victory. Again, let me say that this is not a thing that we'll say is involving politicians. It's involving core, strict civil servants, and of course, a lot, almost exclusively in the oil industry. And I've had occasion to ask that the way people in the oil industry behave, the way people in the oil industry and the central bank behave, is as if they are Nigeria, as if they own Nigeria, and not that Nigeria owns them. So people in the oil industry just believe that Nigeria is responsible. They are not responsible to Nigeria. Nigeria is responsible to them. In fact, Nigeria is doing them. They're doing Nigeria a favor by even working in the oil industry. Now, again, there is the other aspect of people in the public service who disregard the office of the Attorney General, the Minister of Justice. Even if you don't have the Attorney General in situ, you have the Solicitor General who hates the office. And that is the Minister of Justice, and in the absence, the Solicitor General as Permanent Secretary sits in, and all the staff of the Minister of Justice. And of course, when you look at the Minister of Justice, they are perhaps the #1 ministry where every transaction about the government, legal and transactional, should revolve around and should reference. Now, I'm sure Nigerians would observe that when His Excellency President Tinubu swore in his ministers, he took out the Lateef Fagbemi SAN as the Attorney General of the Federation, not swearing him in according to the order of, I think it was alphabetical order of state or something. He took him out as a single person, a single officer, as Attorney General of the Federation, and swore him in. This emphasizes the primacy of the office of the Attorney General of the Federation and Minister of Justice. Now, the people in the ministry in almost all ministries, so there sometimes don't take what they ought to take to the Minister of Justice for vetting. Because when you take it there for vetting, they will look at the implications of this on the economy. They will look at the implications on the country. They look at the terms, like my learned friend has stated there, the clauses relating to arbitration, where it is located. They look at the clauses relating to your competence to even enter into the contract. They look at every other element that is capable of raising liability or otherwise. And then they will advise for or against it. Now, I'm not sure that this contract went through any of these processes, because those who were involved in this matter thought that they were Nigeria and not Nigerians. They were simply Nigeria itself. So I congratulate our outcome, and I listened to the Learned Attorney General Fagbemi SAN when he said, and I appreciate it, that every person responsible for this will be made to account by way of prosecution, And of course, let me congratulate all the two people. My brother, the learned former Attorney General, who was a member of the arbitration panel, whose opinion has been vindicated, and of course Shashore, who was acting purely as a legal consultant in the entire transaction, who've all been vindicated. And we say, whenever you are called upon to do a professional job, know that there will be a day that you have to account for your professional standing.
Okay, thank you very much for your thoughts on that. Let me come to Mr. Odion. The Attorney General, SAN, said that the contract was obtained by fraud in a way that is contrary to public policy, that is abuse of process. So what do you think, in your own opinion, what can be done to promote transparency in government dealings, particularly in terms of business contract?
Thank you, and let me toe the line of Senator Itang by congratulating Nigeria for dodging such massive liability bullets. But just to backtrack, right, in 2008, there was actually a need for gas to power infrastructure. We just launched a big program on natural gas and processing our natural gas. And there was also a presidential committee that was really driving it, right? If you also realize, the P&ID contract was not the only contract that was signed in that process. There were actually about 11 contracts that were signed. And Senator Enang hit the nail on the head. The people in the CBN and the NNPC and Ministry of Petroleum Resources act like they are Nigeria and not that they work for Nigeria, because you then realize the biggest problem that arose from that contract was the fact that the Ministry of Petroleum Resources was acting as if it was an operator in the oil and gas industry. In the first instance, the Ministry of Petroleum Resources does not have natural gas to give because it is not an operator. That he went into that agreement that he would deliver gas to an operator, not only to P&ID, to other players, because he signed with Petrolog and some other companies as well, that he would deliver natural gas. He had no source. There was a third party that was supposed to deliver it, ADAX. ADAX was not a contract with the NNPC, was also not a party to the contract. So it then makes you realize that there was that operational role that the Ministry of Petroleum Resources had taken upon itself, right, without giving the operators the due chance to operate. Having said that, that then means that we must have a clear line where people that are involved in policy should relate to policy. People who are the operators and should handle contracts should be made to handle contracts. We can't have a rule where the ministry is actually playing the role of the operator, as it was in this case, which was what made it very catastrophic. Because in the first instance, one will query, why would the Ministry of Petroleum Resources enter into that kind of contract when it had no capacity to deliver that? That also brings to fore the realization that it's not enough to have technocrats who just want to do the work. I think we need to sit down and look at a full, we need to have the resources, technical resources, to also vet through this project. Let me give you an insight. In 2008, I was involved in a project, in an FLNG project, a floating LNG project. The contract documents, piles and piles of documents, just to design everything, and then the contract itself, the gas agreement, was a lot of it. To imagine that we had the Minister of Petroleum then, Alhaji Rewanu Lukman of blessed memory, and then Odein Ojumogobia, who was the Minister of State, signed a contract. These are learned people, signed a contract that could potentially create challenges. For me, was what was stunning. And then we then had a situation whereby none of these contracts went to the Attorney General's office, right? I'm sorry to say, whoever defended Nigeria during the first instance, you could also see a situation where the fellow did not have all the information to defend us at the tribunal. As a matter of fact, it was a case of who would pay for his fees, who would, for his appearance and co, up until the time of the liability hearing. And then what was shocking to me was, at the end of the day, you present an opinion that we should pay these fellows $850 million. Meanwhile, prior to now, it was who would pay a $1.something million fee to represent us. So you could see that there was a lot of incompetence in this whole thing, in managing this whole thing. And I dare say, the reason why we're here was that the liability judgment, nobody thought it would be in that quantum. Because if it was less than $500 million, we would have paid. That's the sad thing. And we have a lot of these judgment debt awards flying all over the place. In fact, Okonjo Iweala in her book talked about it. Judgment debt scam. So this was appearing to be one. The only reason why we're talking about this was that the scale of the liability was something that nobody could comprehend. Otherwise, have gone down the road as one of the things that we paid, and then let's move on. Thank you.
Odion, thank you. I still want to stay in the studios. Senator Enang, we also have to ask ourselves the question, because of some of the critical elements that Odion has raised. If an expert is providing an expert opinion as a consultant, the expectation would be you go the whole hog, you open up the entire books and then point out what is feasible, what is infeasible. Here, and that report was out there in the public domain much earlier, that everybody knows the Ministry of Petroleum Resources is not an operator in the oil and gas industry. And yet it was claiming to provide gas for this particular transaction. So How then do we situate the role of some of the consultants, whether they are legal consultants, energy consultants, and so on and so forth? What drives them? Is it just you look at the figure and then the person is looking at his percentage commission and say, let's do this quickly and then move on?
I think that it has to do with the mentality, idea, and the godness in the people working in the oil industry. They behave sometimes like little gods. Like that, like I said, they behave as if they're doing you a favor by even working there. And if you interact with them, particularly the leadership of the NNPC and so on, they say, my crude. That is, they say that they own the crude, they own the oil. You interact with them. They say, look, Nigeria has no oil. It is we, NNPC, it is my oil. So it is this mentality in them, and I repeat again, the godness in them, the overall in them, that makes them think they can do anything, and there will be no consequences. After all, Nigeria is begging for oil, begging for crude, so that it could fund its budget, and so they're doing you a favor by providing you something to fund their to fund your budget. I think it is time that we unveil the petroleum industry. It is time to, in law, we say you lift the veil. It is time for us to lift the veil in the petroleum industry and the entire petroleum industry. In this 2008, when they were doing this, that's when we were considering in the House of Representatives and the Senate the petroleum industry bill. And most of these transactions, they went into it anticipatorily that the bill will come into effect and that they will. But we looked at it in the National Assembly, and we looked at it in 2003, 2005, 2007, 2008. Most of those things did not just look reasonable, but they will come with all kinds of offers, all kinds of things, all kinds of they'll tell you, they'll take you, your people, the legislators, to training here, they will take you to training here, but the legislators were firm. And that is why disputes as to different aspects and content and the powers that each of the sectors needed, the powers that were to be vested in each of the subsectors and the powers of the ministry, we had so much problem. That is why the petroleum industry took over 20 years to come, because each minister and each GMD that came wanted to vest almost all the powers in him. Under Desiani, everything was minister, the minister shall, minister. So each of the succeeding assemblies had difficulty in agreeing at what we did. So we didn't have the petroleum industry for a long time. So it is time for Nigeria to unveil the petroleum industry, and it is time for Nigeria to look at almost all other transactions that have been signed, so that it wouldn't be up to the time. It will be until we have an arbitral award, because each of these contracts were like a chain which had almost similar contents, so that it will not be that when each of the contracting parties, while they are sleeping, and they now wake up that this is possible, they now start taking action, then we take our responsibility. We should look at each of the transactions that is linked in this chain of transaction, because they will come to learn from the P&ID mistakes with the issues that were involved, and then still strike at Nigeria in their own contract, and then still, now that there is not much oil to make, not much profit to make in the oil industry, they may seek to harvest the content of the agreement to make some money.
Sorry, let me just jump in there, because he makes a very valid point. See, the P&ID case is not Nigeria.
It's not a loan case.
It's not a low case.
It's a chain.
And it's also a lesson to Nigeria that, look, perhaps we too need to go dig up some of these contracts and look at where parties that we've entered into agreement with have failed on their own obligation. Because if you read the P&ID case, you realize P&ID had not even met certain obligations, but we were sleeping. We could have actually reversed this, taking P&ID to arbitration, rather than P&ID taking Nigeria to arbitration. So it's time for, and he's absolutely right, it's time to really go back, look at some of those contracts, look at where the contract the parties had failed, and Nigeria then take preemptive actions to actually hold these parties to account or pay us liability. It is not every time Nigeria is taken to arbitration and then we have to pay liabilities. Nigeria should flip the script.
I was just wondering, considering the view expressed by Senator Ita Ena, and I'm sure ordinary Nigerians would have experienced this disposition displayed by some of the entities that he mentioned, who have a supranational attitude. How do we go about this? If they're assuming that they're above Nigeria, that they're actually doing you a favor, you know, working for you in the oil industry.
Well, in the oil industry,
or in the CBN.
In the oil industry, the PIA may have addressed some of the powers and the limitations of, or rather the powers of the minister that was sought them by some of the previous ministers who wanted to be the kings and queens of the sector. So you now have a PIA that clearly delineates the role of the ministry, the role of the NNPC, even as a private company now, and the other people's role. So it's very unlikely that this kind of contract can be signed again or will take place again, except NNPC goes to, and it will now be between NNPC and the party, which is an operator. In the CBN, we've just seen, we're getting out of a case where the CBN pretty much was financing, it was the government of Nigeria, let's put it that way. And I think it's time to also look at the powers of the governor of the CBN. And luckily, Senator Inang is here. The National Assembly needs to look at where we have these people sitting down in their positions and then they take that role, as you say, not in the best interest of the country, right? So a lot of the laws need to be looked at, but at the same time we also need to be careful not to strangulate their position or make them ineffective by putting too many checks and balances such that they cannot move. So it's a fine balance that one has to strike, but clearly there's been abuse of process in the P&ID case. It was very clear that had there been a clear separation between the roles of the Ministry of Petroleum Resources and the operators, we will not have fallen into this trap, because clearly if ADAX had been brought on board that contract, then the liability literally would have been on ADAX, not on Nigeria, because ADAX was the one that was supposed to have provided the gas, not Nigeria, because we didn't have it.
Okay. Thank you very much, Mr. Odion, for your thoughts there. Let's go to our Zoom guest, Latif Yusuf, if you are still there. Okay, Latif. Okay. Now, I know that you have been following the legal process from the onset. How would you describe it? Would you say it's been fair and very transparent?
I made a reaction on LinkedIn, I think it was yesterday, when a colleague who we also discussed this case extensively in the last 10 years. He posted something and my comment was, this is a bittersweet judgment. It left a very weird taste in my mouth. Now the reason is, that judgment is a roadmap into how you do business in Nigeria, the murky waters of the Nigerian civil service. And it also gives, because, you know, you need to understand one thing very clearly. You have less than 1% chance to succeed in challenging an arbitral award that was rendered in England. Because England is a pro-arbitration society. So you have less than, your chances at succeeding in challenging an award seated in England is almost next to zero. There's really no chance. Now, the exception will be fraud. Because the English courts don't want to be involved in somebody that went into a contract and said, we do not want courts to determine disputes that arise out of this contract. We will decide this dispute before an arbitrator. Then the English court will be like, okay, go ahead, go before the arbitrator. If you have any issue, we'll just support this process. We're not going to impose our will on what the parties have already expressed in their contract. So fraud is now the outlier because there's a very popular dictum of Lord Bingham when he said, fraud unravels all. So even if we say we will not do this, but somebody has made out a claim of fraud, then we'll stop everything to sort of bend over backwards. So that judgment of 140 pages, it was quite difficult to read because it's a judgment of a high court. It will be reported in all the law reports in England. So it's a permanent record for life. And if you read that judgment, you would understand that that is not the kind of permanent record you want to have about your country. More so when you operate in the diaspora and people begin to, they question you, they ask, how did, two Irish men come to Nigeria and, are able to do this and get the Nigerian civil service to actually compromise the system in their favor. So we need to now discuss things of national identity, patriotism. We have to begin to question why can this, how does this really even happen? What kind of society, what kind of situation would exist in a society to enable this to occur? So those are the questions that we need to address more fundamentally. And I align myself with the distinguished guests on the bit about the way civil servants, especially in the energy industry, behave. I align myself completely with that reasoning. So these are some of the questions that I also want us to address on the program, if we can.
Latif, thank you very much for the views that you have expressed. But I think that we also need to clarify the point. It is not every Nigerian. We're over 200 million. If you add those who are in the diaspora, that will make us, again, well over 200 million. It's not every Nigerian that gets involved in this kind of shady transaction. And so the reputational harm arising from the court judgment is less on the entire population of Nigeria than that tiny clique that perpetrated this contract. And more so for the, if you may, the Irish gangsters who formulated this and then found collaborators back home. The bottom line is what His Lordship said in that judgment. That's fraud. It's pretty elementary in the law of contract that fraud is a vitiating element in the validity of a contract. So it's a restatement. But how we got ourselves entangled into all of this is what you and then the two other guests who are here with us in the studios have been talking about. Yesterday, we touched on this issue briefly because the matter was just unfolding, and we said we needed more time to deep dive into it, which is why we are coming back to it. I had raised the issue about the location for arbitration. That's to say, the forum. I didn't want to get into more legalese. I find it curious because virtually everybody you see these days has a suffix, fellow Chartered Institute of Arbitrators and so on and so forth. Everyone is an arbitrator. And yet, when contracts are being entered into in Nigeria, which is in law, you say lex loci contractus, you will be placing the forum for arbitration in some other jurisdiction, either in Paris or, as you said, in London. What informs this mentality, if you have an idea?
Sorry, I didn't quite get the last part of your question, sir. Sorry.
Okay, my last question, but the last part of my question is as follows. You find that when contracts are being entered into, say in Nigeria, which is lex loci contractus, the clause in that same contract will be indicating that the forum for arbitration in the event of any dispute would not be Nigeria, as though we had no competence in dealing with the matter. The choice location will be either Paris or London. And I'm asking you, if you have an idea, what informs this kind of disposition?
Thank you very much. What I would say would be that there is no indictment on the Nigerian judiciary. I have in the past relied on judges to get orders to maybe restrain somebody from being cheated. The Nigerian judges are competent. They are very thorough in their job, and they know what exactly they're doing. So the question now is, a contract entered into in Nigeria, drafted by a Nigerian law firm with an arbitral clause in London, Paris, or maybe Singapore. Now, the question now is, what makes a good seat of arbitration? What are the implications of a seat of arbitration? Now, a seat of arbitration, that is the place, that's the what they call lex arbitrae. That is the place where the arbitration is going to take place. Now, the courts of a lex arbitrae, they have the jurisdiction when, after the award has been rendered, to hear any challenge to that award. The award is seated in London, and London court would have the jurisdiction to hear a challenge to set aside the award. Now, this is the question. The question then is, why do Nigerian lawyers draft a contract involving Nigerian parties with, as you said, contracts situated in Nigeria, but they choose another place to hear the dispute? I would say that it's more of a procedural problem than any issue around corruption, because I don't think it's more of a corrupt issue. So let me give you a scenario. I have a senior who told me about an award they received. They got an award in favor of their clients in around 15 years ago in Nigeria. And that is currently still pending, I think, today. So one of the parties just decided, okay, I'm not going to pay this money, and I will get a senior lawyer to ensure we entangle you in that very lengthy process of litigation in Nigeria. And there are a lot of tactics that lawyers can employ. But these tactics, you cannot employ them in a place like England, because it's not possible. We have an overriding objective. We have the way we conduct civil proceedings here. So it's almost impossible. But now, to be fair on Nigeria, my Inn of Court, for instance, that's the Honorable Society of Lincoln's is currently celebrating 600 years of existence. Now, the legal profession in England is about 700 years or plus. So we're talking about a jurisdiction. They've made all the mistakes. They've come from very dark ages where litigation would take lengthy periods. Judges would die. Another judge would take over the case. They'll start afresh. They've tried all sorts of systems. So they've perfected, in quotes, their system. So things, you don't really hear much about procedural issues. But in Nigeria, a party that is desirous of not paying an award that is rendered in Nigeria has all the facility available to them to stultify that process by creating a fictitious challenge most times and just lock the award in lengthy litigation. And sometimes you have lawyers, and if you go to the Nigerian bar and take a poll of lawyers who have had experience with awards rendered in Nigeria, they will tell you this, that 10 years we're still in court, there's a challenge, the challenge doesn't really have a headway, they are bringing issue of fundamental rights. Now, the award, the High Court says, yes, go pay this money, they go to the Court of Appeal, they are changing counsel, somehow the judge gets retired, they start all over again, they raise preliminary objection, something happens, they go interlocutory to the Supreme Court, they go down back, they file a stay, So at the end of the day, they just deny you the fruit of your award. So I think that's more the issue at stake here. So it's not anything that has to do with maybe corruption of judges in Nigeria. It's not, because my experience with Nigerian judges is that I have found them to be very, very distinguished. But sometimes the judge's hands can be tied when you are before a lawyer who is very well seasoned in guerrilla tactics. That's what we call that.
Thank you very much, Lateef Yusuf, for your contribution there. And the major thing he talked about there is the procedural challenge that we have in our judicial system in this country. Senator, how can we tackle that challenge? What is your take on that?
The process of arbitration and alternative dispute. I want to think I agree with him a lot about the guerrilla tactics, but the judges and the courts and the rules of practice has arrested a lot of that now. I'm sorry that I have to bring a live case here. Okay, it was disposed of yesterday, a case between the Academic Staff Union of Nigeria and the Ministry of Labor and the Registrar of Trade Unions. I was involved in doing the case myself and J.E. Igwe at the instance of the Federal Ministry of Labor and Senator Ngige as Minister of Labor. It was at the National Industrial Court. Now, under the rules of the National Industrial Court of Nigeria, where the parties opt for ADR, the court will, on its own, the court will refer you there. And of course, the court could look at the issues and on its own refer you to the ADR process. And it has time limit. In this matter, we as counsel to the federal government were given, we referred to the ADR Center of the National Industrial Court. It had time limitations. It has time limit, and the time limit was exhausted. We came back to the open court for report of settlement. It was reported we couldn't, and the court took a definite late date yesterday and today for the hearing. But the issue could not be heard. The other parties, something happened, and we got the matter struck out yesterday before the president of the National Industrial Court. What am I saying now? The processes are time-bound. They set time limit in each of this. It is not open-ended, as it were. So the fears and the reservations expressed by my learned friend via Zoom has been addressed by the rules of court now in each of them. And then my brother said that there are a lot of other issues about contract, and a lot of people say there are fellow Chartered Institute of Arbitrators and so on. There is qualifying examination to become an arbitrator, and a lot of these people, there is, when there was in the National Assembly, we were working on amending that law on arbitration, and in the end we couldn't really succeed. And so something needs to be done more about the arbitration law in Nigeria, because it leaves a lot of room for things that my brother via Zoom is expressing, and my brother with you.
Oh, okay. Thank you for your contribution there. Let me quickly go to Mr. Odion, because he will be leaving us in a short while. This whole scenario, how do you think it will actually affect Nigeria's ability in foreign investment, attracting foreign investment into the country, to the economy?
No, to the extent that a court in London, again, the jurisdiction is also quite significant in the international community. A court in London has declared that the contract was obtained by fraud. I do not see any impact in terms of our abilities to attract foreign investors in, right? But having said that, we need to learn how did this happen, the processes leading to that contract, and make sure that contracting entities who are contracting for Nigeria actually take this case, the tribunal and the case, and they study it, so that when they go into contracts, or when some foreigners come and say we have foreign investment, we are foreign investors, we don't fall into that line of saying, okay, let's quickly sign, because all those guys are looking for is for you to sign a document. And unfortunately, they will never agree or admit or accept to have arbitration in Nigeria. Because they will tell you that they're foreigners and they don't, whatever. And you would always find a legal person that will write an opinion that says, don't do arbitration in Nigeria. Let your forum be Paris, Singapore, or London. And
can't we insist that the arbitration be done?
You're the one looking for investment.
Oh, okay.
That's the thing. You're the one looking for investment. Okay. So you're not the one that will determine, except, see, NNPC has a strong role. So if NNPC give you a contract, right, and NNPC can actually tell you, I want the arbitration here. But it depends on the contract, the powers or the influence of the other party who NNPC is entering going into a contract with. But if you're the one calling investors to come, they would always tell you, I don't know your legal system, I'm not familiar with it. Arbitration, forget about the laws, the governing laws. Arbitration first, which is outside the governing law. So they would always insist on that. But the point I make is that this case is something that all ministries, MDAs should study. Even the National Assembly should study. Let's see how we can prevent similar instances where parties rush to sign contracts on behalf of Nigerians, and then they expose us to liabilities. And one thing comes to mind. You remember the National Assembly? There was the Chinese loans, where I didn't want to bring that up. There was an issue with where the law, something about the law, and then I think the Chinese government said, no, if you guys are going to put the law here, we may not be interested in this loan or providing something like that. So those are issues that we must tackle, find a middle ground to make sure we're able to attract investors, but at the same time, we're not exposed to these liabilities that these contracts will impose or create down the road.
Well, I think we had a conversation on that subject, yes, with respect, and the then Attorney General of the Federation, Abubakar Malami, SAN, was one of our guests, and the then Minister of Transport, Rotimi Amechi, also was here. But arising from your contributions, gentlemen, including Latif with us via Zoom, one point, namely that it is in all cases that we sit back and then be taking what Muhammad Ali would call the rope-a-dope. We're not the only ones to be taking the punches. We should also get out of our corner and say, look at the contracts. Where have the other parties failed to perform their terms under that contract, and then also go after them? So, yes, so we mustn't be, as it were, I mean, to be plain, we mustn't be, lazy is not the word, we mustn't sit on our rights. Because if you sit on your right, that's your headache.
You don't wait to be the defendant.
You don't wait to the defendant always. So you take the attack to the other side. But one point, before we take this short break, I've been trying to recall the conversation we had, because you were our guest on that occasion, one of our guests. And I think it must have had to do with the supply of refined petroleum products or something. And you said, you made a point that day that, look, it's possible that there are some persons who are sitting in cozy offices somewhere in Europe or wherever and looking at the papers and then seeing how, I'm sure now you are nodding. Yeah, so just say, look, okay, how do we game Nigeria?
Yes.
So it's how do we game Nigeria? If that is the case, we are all, because it's become now the it's not a mantra, because that's misleading. Oh, we are looking for foreign investors. This is the trap we are likely to fall into.
Question.
Yes, if our eyes are not open, our ears are not open, and we don't get the right kind of experts to back us up. What are your thoughts on this?
So again, true, there are people that just look at it, they realize that our processes are not as up to date, or we don't have too many expert resources. Our civil service, unfortunately, can be influenced in several ways. You know, it's very painful that the entire bribes given in this whole thing was not even up to $5 million, but then we're exposed to a $6 billion liability. You know, so they frame things and then they come with contracts and present as if they have funds. They don't have funds, really. But then we've signed and then they start to, you haven't performed. So it's important to realize that we must follow the procurement processes in Nigeria. We have the BPP. If you're entering into parties, the BPP was set up there to protect the country, right? So people we must be familiar with our procurement laws. Our procurement laws should ensure that the people who supervise it are also knowledgeable enough. In this instance, this was a very technical contract, and it was shocking that we didn't really involve a lot of technical experts that could have also drilled down. You can't sign a 20-page GSPA. It's not possible, but yet we signed it because we didn't have the right technical people weighing on it. So I think the lessons here is, look, everybody should sit down, make sure that when you're entering into a contract with Nigeria, look at the liability first. If we don't perform, what is the liability to my ministry, to my company, to Nigeria? And then once you look at it from that perspective, you then decide that if you need this contract or you need this job done, then you must make sure you're able to fulfill your own part of it. Second, sit down and make sure that the other party is also able to due diligence him. Not that he says he has $10 million and then he says, no, I have this letter from HSBC, which always is a fraud. Anybody that comes to a HSBC letter is fraudulent. Okay. You know, so that level of due diligence, we must invest time in doing it. Otherwise, we'll keep falling prey into these young boys and girls in Europe, Switzerland, and who just come and wave one nice check, even a copy of the check, and then they say sign this agreement, and we're rushing to sign.
Thank you very much, Mr. Odio Omofoman, for your thoughts, for your contributions on today's topic. Mr. Odio is the energy expert and managing director, New Hampshire Capital Limited. Thank you. We'll now let you go, and we'll take a break. Good Morning Nigeria continues. Stay with us.
Thank you.
I promise that I shall remain committed and serve faithfully. I also invite all to join this enterprise to make our beloved nation into its better self. We can do it. We must do it. We shall do it.
Say hello to GoTV's newest package. GoTV Super Plus has all the great channels you love on GoTV Super. Plus, big-time international and kids channels the whole family will love. Plus, plenty of live Premier League action on Super Sports Premier League channel. It's the package you asked for, and we listen. GoTV Super Plus, available from 1 August. GoTV, love it.
The counsel of our fathers.
I will urge and advise our younger generation to use talent and brain to sort out problems, not arms.
Nigerian youths, let's build our nation together.
Nigeria means unity. Nigeria means freedom to me. Nigeria means greatness to me. Nigeria is indivisible. There is nothing you can do. We all have to savage it together and learn to love each other.
Yeah, welcome back. It's still Good Morning Nigeria, coming to you from the Nigerian Television Authority, NTA, here in Abuja, the FCT Cup. We still have Senator Inang in the studio, and I want to read a passage from the Attorney General press briefing yesterday. And what he said was that he described the P&ID. He said P&ID was exactly the type of entity prepared to engage in bribery to achieve its aim, to undermine the administration of justice in Nigeria in the pursuit of riches beyond dreams and avarice. Now, looking at that, let's look at the role that corruption played in this saga. I mean, what can be done to address this?
Excuse me, I want to apologize. Now, it is simply due diligence. When somebody is coming to contract with you, there is some processes that you need to undertake, and perhaps sometimes you do what they call proof of funds, whether the people have funds to undertake what they want, what they think, what they want to do. And I want to urge the learned Attorney General that he's got a lot on his plate, because this is just one of the ones that has blown open. There are the other ones that are budding. There are those who may have waited in this series of contracts to see the issues that will be that will be the outstanding matters in this matter before they take us to arbitration. He should preempt them. We should preempt it, the series of contracts. And of course, these are the kind of things that even happens in loans that Nigeria has taken, Nigeria has guaranteed, particularly loans that are taken by states. Most of those loans don't get to those states. They don't get there. Most of the loans, the funds are trapped somewhere for the parties, for somebody. Even the loans we signed for Nigeria, which we are now paying, if you look at the contractual terms of the loans, most of those things don't arrive Nigeria, and yet it is now that Nigeria is paying. So I will urge the Learned Attorney General, the Minister of Finance and the Coordinating Minister of the Economy, and the Presidency to take one step. Otherwise, what we are paying, we ought not to be paying. One, the Debt Management Act provides that the National Assembly shall approve the terms and conditions of the loans. When you look at the approval and the vote and proceeding that are issued from the National Assembly, you do not see the terms and conditions of the loans. You rather see the National Assembly saying the terms and conditions shall be as approved by the Minister of Finance. And the law says delegare non potest delegare. When the power is delegated to you, you can't redelegate. So the National Assembly has left Nigeria vulnerable in the way they treat every request for loan application. What brought out this? It is the fact that Nigeria has to look again at what we are paying, because most of those things did not arrive this country and we are just paying shell debt, a debt which is a shell. I will urge the Learned Attorney General and the federal government to set up a judicial commission of inquiry. Judicial commission of inquiry to inquire judicially into all the debts that we are paying today. What were the terms and conditions? How much arrived Nigeria? What were the agreements? You know, what was the agreement? How is it perfected? These things we are paying. What did we actually take benefit before? Because I am not predicting doom, but I'm seeing it impossible. And I repeat it, given my experience in government, in the legislature, in the executive, that Nigeria will default in many of these loans because of the fact that we're not going to be able to service those loans, and we will be taken to arbitration in many of this. So we should take preemptive action to even audit ourselves to see where we are. What did we do right? What did we do wrong? How can we salvage the situation before we are taken to the forum outside Nigeria for settlement of debt, or before we even start saying forgive us our loans, debt write-off?
No, so but just 1 minute, please. Just one. The issue of corruption, you did not address it because, I mean,
what I've even said,
yes,
is corruption.
The Nigerians that are involved in this matter, because this company wouldn't.
No, I think I've answered, because I heard the Attorney General say that they are going to prosecute them.
Okay.
And that is what I'm saying. Don't just wait to prosecute when it is open. Front load the prosecution by investigating some other ones which are pending. Okay. And a lot of those people who are involved in a lot of them have left, but their pension is still there. They're still entitled to many things. So having agreed to prosecute this set of people, look after those ones which have not yet busted open, which have not yet taken you to court. If it be possible, take them to court first, or seek the cancellation of those contracts. Look at all the terms and conditions. Unfortunately, the way the Petroleum Industry Act is, it has almost killed or kept the Minister of Petroleum at the back line. Minister of Petroleum is like a beggar now. It's like beggarly to the petroleum, the upstream, the midstream and downstream, and then the upstream sectors of and then the gas of the Ministry of Petroleum, then the NNPCL, because the way the Petroleum Industries Act was crafted.
Senator Ernad,
yes,
I imagine what you're talking about, these are like legacy contracts.
Yes.
So the legacy contracts have not been annulled, by the coming into force of the P&ID.
Agree.
So but the critical point is that the government or the appropriate authority now take a look at any of those contracts and where we can mount an attack.
Yes.
Then we mount an attack against firms or other contracting parties that have breached the terms of those contracts.
That's my submission. Yes.
That's fine. But there is also the subtext. I don't know if he's waiting. I have a question for him, but the subtext of it. Yes, P&ID has been branded a fraud.
Yeah.
And so whoever was involved in that will be prosecuted, and I think some of them are also being prosecuted. But there are a number of perhaps P&ID-like contracts that have not yet come to the fore. So how should our country respond to officials who are responsible for endorsing such contracts? Would it be in the realm of economic sabotage? If you like, some would say economic treachery. How should a country respond? Because at the end of the day, you are putting not just Nigeria at risk, but Nigerians ultimately at peril. How should our country respond to such individuals? What should be the sanctions? Because as it were now, it would appear that they perform these functions in the line of duty. And so whatever comes, you bear the consequence as an entity. Yeah. If it's time for the person to retire 35 years or 60 years, you go.
Yeah. I think it is simply, that's what I'm saying. I'm saying that we should look at those the instruments and documents in advance before it gets to the time that the people will rather sue us. And you've also said that we should be on the attack. But you cannot attack when you have not looked at the contract, and then if it's necessary you prosecute them, take judgment against them, or you in the alternative seek arbitration as in that contract to nullify or to claim damages from those people for breaches, or to seek for nullification in advance of those contracts for fraud if you can prove those elements. So it is for Nigeria to look at them, not waiting for them to take us to court or arbitration first. So the Office of the Attorney General, then the Minister of Petroleum Resources, the Minister of Petroleum Resources, Oil, and the Minister of Petroleum Resources, Gas, should be able to say, look, we are in the eyes of the storm now. Being in the eyes of the storm, let us call up almost all the contracts of this nature and see the extent to which Nigeria is obliged or charged or is going to be liable in the in event of failure. And of course, to what extent have each of these contracts signed been implemented? To what extent has it laid in the just on the shelf, and then we now take steps to cancel them so that in advance we avoid liabilities? Or we simply invite these persons and say, look, this is and this and that and they had to be done. It hadn't been done. We want to terminate this. Because in every contract, each of the parties can mutually, both parties can mutually call off the contract or renegotiate the terms of the contract.
Thank you very much, Senator, for that, your thought there. Let's go back to our Zoom guest, Lateef Yusuf, if you're still there. Earlier you said you attributed procedural process to one of the factors that we have in this country. So what can Nigeria judiciary, how can Nigeria judiciary improve its handling of international business disputes?
In England, there's something we call the Wolf Reform. Lord Wolf reformed the entire civil procedural landscape. A retired jurist, one of the best brains of his generation. He sat down, looked at what really causes delay and what are the procedural problems we have in this country. Then he introduced what we call the Wolf Reform. And that is the current landscape in England at the moment, where cases proceed expeditedly. And if any party is found to have delayed the case, they will be liable to pay costs. Sometimes lawyers who do delay personally would pay personal costs. So we have this general statement that we make in England now. We tell you that the fear of cost is the beginning of wisdom. So cost is the main issue. So the idea is to rein everybody in and ensure everybody's behaving correctly. Now, bringing that back to Nigeria, just appoint 5 retired Supreme Court justices in Nigeria to reform the whole landscape. Give them 6 months, they'll do it. I have 2 or 3 judges in mind, but I'm sure I would not have the power to nominate. But there are a lot of retired justices of the Supreme Court that know the problem, and they can, if given the powers, go in and address this problem, give us an overriding objective like what we have in Nigeria. Now, beyond that, I'd like to conclude my remarks, if I have like maybe 1 minute, by reading just 2 sentences from paragraph 217 of the judgment, if I may, sorry. So the judge said, P&ID's improper retention of Nigeria's internal legal documents received at various points during the arbitration enabled P&ID to track Nigeria's internal consideration of merits, strategy, and settlement during the arbitration. P&ID's improper retention of Nigeria's internal legal documents also allowed it to monitor whether Nigeria had become aware of the fact that the tribunal and Nigeria were being deceived. These are confidential documents divulged to external parties by civil servants. So, as a Yoruba man, I'm sorry that I'd have to speak Yoruba, but I'll give you the translation. Would say "Tiku leobakwani to deolekwani." That means the death that would kill you would come from your house, not from outside. So 2 Irish men would not come to Nigeria and do that without support, collaboration from the inside. And that is where everything really is. This is a case that really points to our internal problems within the ministries, as has already been addressed. So that's my remark on that.
I wanted to stay with you very briefly, but I know that we're getting out of... Come on, I just need to clarify this. Thanks a lot for what you said. Those 2 paragraphs you read now and the interpretation, again, takes us back to the question I asked Senator Enang, namely, that how does a country sanction persons who are engaged in economic sabotage or treachery, or in this case, economic espionage, to the extent that you are divulging secrets to an entity that is hell-bent on ruining the finances of our country. That's on the side. The 2 other guests here with us in the studios earlier talked about the need for the Ministry of Justice to play its role as the fulcrum for clearing international transactions or even local transactions or contracts, as it were. Now, very briefly, I know that Professor Bolaji Owasonye, the outgoing chairman of ICPC, is an expert in international economic law. Is this an area that we haven't exposed ourselves to, and therefore will require capacity building for even staff of the Ministry of Justice, international economic law, international trade law, and so on and so forth, so that when these documents come, they can be ahead of whoever is trying to game the country? Quickly.
Yes, I don't think there's any problem with capacity. It's just, it goes down to patriotism. Everybody goes there to see what they can have of the national cake. So that's really the mentality we have to address. And we have to address this from the schools, from primary school, where we begin to teach children that delayed gratification is okay. It's okay to have just 1 house, and to have that house at the age of 45 or 50. It's okay to have just 1 car. And if the car is okay, you can drive, and it's okay for your children to attend, decent schools. They don't have to school abroad. And if these children do graduate, they can work very hard and find themselves in Paris, anywhere in the world, write bar exams in England, in New York, anywhere. So we need to teach delayed gratification so that people don't go into the ministry thinking, there's one salient point in accounting where they'll tell you that there is no internal audit system that can beat connivance. If the internal auditor has agreed to steal, the security man has agreed, everybody in the department has agreed. You cannot block that. And this is a principle recognized by the ACCA, which is more like one of the most internationally recognized accounting body in the world.
Thank you very much, Lateef Yusuf. We are sorry we have to cut you short there because of our time. Thank you for joining us today on our program, Good Morning Nigeria. And also, I want to express appreciation to Dr. Ita Enang, lawyer and former presidential aide, for coming on Good Morning Nigeria. Thank you so much.
Thank you very much. Thank you very much.
Now, we'll now take our sports, go to our sport desk for some sport news.